So welcome everyone. Thank you for, in some cases, staying on, and others for just joining us. We've been having an excellent conference virtually thus far. This session is all about convening a stellar assortment of leading lawyers in the blockchain and cryptocurrency space from the private sector. Personally, for me, I view our private sector lawyers in space as kind of the vanguard, the front lines, ear to the ground, in many cases protecting a lot of the good actors in the space while they're doing their work diligently. From bird's eye view, I don't want to belabor this because I think we have a good number of excellent speakers and I want to give them each time. From bird's eye view though, I've sensed a shift in speaking with a lot of leaders from the dev side, a shift from kind of this illegal wishful thinking that laws and regulations might not apply necessarily to kind of this understanding that they very much do, especially when we're still living in this world under sovereign laws, right? So there has been some shifts in the blockchain space. It's rapidly evolving, fascinating. So I really just want to hear perspectives, insights, just food for thought really from each of our speakers. And I want to emphasize that thus far we've kind of had a panel speaker format. I think it'd be fine to kind of open up further, really make this a working session of sorts. So encourage free-flowing conversation. To that end, there's not going to be a strict set order. You can each feel free to jump in, introduce yourselves, and we can take it from there. And I'll be happy to kind of help loosely moderate if there's a lull, but I don't expect her to be with such an excellent, again, collection of blockchain legal minds. So without further ado, if anyone would like to begin among our speakers. If not, I will pick like a school teacher on our.
Okay. Yeah.
Okay. Go ahead, Rebecca.
Okay.
Columbia scene.
Okay, my name's Rebecca Rettig. I'm a partner at a firm called Fisher Broyles. We're a national and now a global firm. We just opened an office in London. I'm the co-chair of our fintech practice along with Adam Ettinger. I'm in New York, he's in LA, so our fintech practice is very national. And we have about almost 30 lawyers in our fintech group. We view fintech and blockchain as incredibly interdisciplinary. And that's how we practice as well. We make sure we pull in people from all relevant parts of the legal world to be able to service our clients. We have a lot of big clients in the DeFi space. We have traders, and we both do corporate work and litigation and regulatory work. My work focuses on litigation as well as representing clients before various regulatory bodies, including both the SEC and the New York State Department of Financial Services. And I'll stop there on the intro, and maybe we'll do intros and then we'll maybe each go through and talk about our views on what's coming down the pike in the legal world, in the blockchain space.
Sounds like fun.
Yeah, that's great. This is Barbara Jones. Sorry, no picture. As I explained to Stephen earlier, the video is coming through my office where no one is at the moment. I'm based in Los Angeles. I'm with Greenberg Traurig. I'm the global co-chair of our blockchain and cryptocurrency practice group. We have over 85 lawyers on an interdisciplinary basis. So we pick up securities, corporate, fund formation, commodities, tax, cybersecurity, privacy, bank regulatory, exchanges and trading, just about everything and anything from soup to nuts within this space, which is great. As Rebecca was saying, it very much touches so many different practice areas within the firm. You really have to do it on an interdisciplinary basis. We have 22 lawyers total within the firm across 41 offices or 43 offices domestically and internationally. So our advice is not limited to U.S. matters, but also international matters as well. I myself am a corporate transactional lawyer. My expertise is in the securities area, so I've spent a lot of time with the SEC helping clients structure tokens and other types of transactions within this space. I'm also on the Government of Bermuda's Global FinTech Task Force, helping them address issues in this space as well. So with that, I'll turn it over to Ken.
So Rebecca, hey, how are you? Good to see you. Good to meet everybody. My practice is very similar to Barbara and Rebecca's when it comes to the sort of the space itself. I work with a lot of our colleagues in our transactional practice group, our payments group, in our various money laundering departments. My area of expertise is as a former SEC enforcement lawyer, focuses on the securities litigation side. So both interacting with the SEC enforcement division, and then also I'm handling a number of securities class actions that have been filed against various different entities and founders that have, gotten into the space. So my I'd say bent is a little bit more litigation related than transactional, but I do work pretty frequently with our partners in other areas in the startup phase of different programs and launches. And more, I'd say my personal experience is probably more in the adversarial mode than some of the other folks perhaps on the call. But I do consult sometimes up front to try to avoid, getting into that phase at some point.
Great. Who else has not spoken yet? Emily?
Hi, I'm Emily Kapoor from Quinn Emanuel. I'm actually taking the spot of Dave Grable, who's the head of our crypto practice, but was pulled away at the last minute. So I'm helping one of a few folks working on our crypto practice group. I'm actually an economist by training. I should say Quinn Emanuel is a disputes-only firm, so we don't do any of the corporate work, but we've done quite a bit of crypto litigation, and actually, somewhat unsurprising in a space where people value privacy, we found that a lot of the disputes coming to us are private arbitration disputes that have not become public in any way. And so I can't actually say who all of our clients are, but but we've been working in this space for a while. I've been working in this space since 2017. We found a lot of really interesting issues coming to us relating to valuation, which has been incredibly tricky. We're already seeing, we do a lot of finance work, and we're already seeing these really interesting crossover cases where you have, bespoke options denominated in crypto that you then need to value. And so those have been fascinating. And then, as others have said, I mean, lots of interdisciplinary stuff running from, antitrust to patent to your more traditional securities stuff. And we're certainly, drawing on partners from all of our different practice areas to serve clients in these areas.
Fascinating. Thank you. Finally, last but not least, Steve, if you are there.
I am. Hi, I'm Steve Aschettino. I'm a partner at Loeb & Loeb. We have about 400 lawyers. I'm mostly located on both coasts. Our firm actually just celebrated its 110-year anniversary. Best known historically for entertainment law. Little known fact, we actually did all of the legal work for initial Charlie Chaplin movies. So we've been doing that for quite a bit. And our technology practice arose through our work with media and transformation over the years. I lead the payments technology practice at Loeb & Loeb, and I co-chair the blockchain gang, as we call it. I've been in payments since 2008, and Bitcoin was born, as I'm sure everyone on this call knows, in 2009. So I've been watching cryptocurrencies since their inception, essentially. I come at crypto, blockchain in general from the technology and the payment side. Our blockchain gang leaders, we have 4. 2 come from the technology side, me being one of them, and 2 come from the security side. And that's sort of how we go about structuring our practice. We, of course, work with many other practices as well. And we do a lot because of our roots in the sort of media, advertising, and related areas.
Wonderful, thank you. So staying true to the theme, the title of our session, law firm goals for this year and then, let's say, 10 years onwards, especially in light of the current crisis, which I think has highlighted a lot of perhaps the benefits, the alternatives available to the economy, to businesses, to developers, and so forth. I'm just curious what you see as trends for this year. Obviously, it's been disrupted to a great extent, but the building continues. A lot of exciting work. I do see some fairly powerful projects, which are, of course, not following the typical, the old bygone ICO model, but have raised in more traditional ways, sometimes in hybrid fashion. But they're building very actively. At the same time, I'm sure class actions will continue to extend. What do you see? What do you see as the trends, and also you have your goals as a firm in terms of approaching clients, potential clients, and even regulators and so forth? Just food for thought.
Yeah, so this is Barbara. So one of the things that you mentioned initially, Stephen, was, has the industry kind of accepted that you're not going to be able to avoid law and regulation within this space? And I think, as everyone on this conference is aware, over the course certainly of the last 3 years, we have seen a tremendous evolution from a Wild West sort of scenario to an acceptance that we had to go along with the regulators, and the regulators weren't going away, and the regulators are still trying to figure out all of this. But in line with that, I think there's continuing to be an evolution amongst what we're seeing in terms of trends, private equity groups, large institutional investors who have been moving into the space, who, when it was back in the Wild West days, were very reluctant to do so. And we see them coming in bigger plays now than they did, a year ago, and certainly 2 years ago. So that's one trend that we're seeing. The other trend is a continuing disruption of major industries, whether it happens to be within the media or supply chain or infrastructure or banking. We don't see that stopping. We see, blockchain taking hold, being much more widely accepted than it was. We're certainly of the firm belief, as I'm sure everyone is here today, that it's not going away. It is the future. It will continue to evolve. It will continue to get broader and broader acceptance. And I think to your point about what impact is the current pandemic happening, the need for efficiency, the need for transparency in some of the service platforms in particular, as well as security issues, has come very much into play. So those are perhaps very broad strokes, 3 of the trends that we're seeing.
That was excellent. Thank you.
So I'll hop in and build upon what Barbara was saying, and I have sort of 3 trends, but 2 of them go together. I would say one of the biggest trends our firm is seeing is in the decentralized finance space. These platforms continue to build. They continue to be a big hot spot of interest. I can say even in the last few weeks, a lot of these VCs have come to these platforms and said, we're ready for you to do a raise. Can we invest? So I think that there is a very specific interest in seeing these different types of protocols and platforms continue to grow and be a true alternative to our traditional or legacy finance institutions, instruments, those kinds of things. To put something that goes hand in hand with that is that DeFi at this time is largely unregulated by any one particular regulator, although obviously all the existing regulations may apply to them depending on what type of service that the protocol or the platform is providing. And so figuring out how to regulate within a DeFi space, including where there may have been a software developer who has now really stepped back from the platform and the platform's decentralized, is very complicated. So those 2 go hand in hand. And then, and I think Ken and Emily may speak to this as well, and we all just saw this last Friday, but a spate of about 11 lawsuits were filed on Friday, all securities class actions against very big players in the space. I think all of us who litigate in the space have been waiting for this. I have, and have, seen it coming down the pike for at least the last year, if not the last 18 months. And I think this is the opening of the floodgates, quite frankly. There have been, both SEC enforcement actions filed, as well as small, private class actions, Tezos, Ripple, things like that have been going on. But to see a big slew of private class actions come out all on the same theory in the same day by two very well-respected litigation boutiques, I think really is a big signaling for the community that everybody should be prepared and start thinking about, what happens if they're named in the next suit.
Emily, or Rebecca, sorry, this is Barbara again. Just on that point, do you think that the Telegram action and the recent decision had an impact in helping to open those floodgates?
I don't think it helped to open the floodgates. I think it will help open new floodgates, but the Roche Rolnick firm has been litigating in the space for a while, and Salendi & Gay is well known in terms of prosecuting novel securities class actions. Philippe Salendi did a lot of the private plaintiff RMBS litigation back after the 2008 financial crisis. So this has obviously been planned for a while. To get 11 class actions ready definitely has been at least a months-long process. I think the timing is probably just coincidental. But I do think post-Telegram, there's now a lot of information out there, especially about people who thought they were fundraising and did so maybe even in a compliant manner, not having that security anymore. Granted, Telegram is a district court by a very well-respected and good judge in the Southern District, and it is up on appeal, but I do think it opens up new floodgates, not these, but different ones.
Yeah, just to jump in on the last piece, I agree with Rebecca. I think these have been in the works for a while in order to, to marshal together the complaint. They would have been working on it for a while. Perhaps they up the timing of the filing because of the Telegram case, just to capture maybe some of the press. But I think what you're starting to see is the plaintiff's bar realizes there is real money to be had here. So traditionally, plaintiffs' firms are pretty selective from a business model perspective about going after somebody who doesn't have any money, right? Unless you have deep pockets, they're not going to waste their time. Regulators have a different prosecutorial charge, obviously. And I think what you're starting to see is that a lot of the entities out here are starting to mature and become real viable operations with some, amount of capital. And the plaintiffs' bar now recognizes this and is becoming more active in that they think there are now some deep pockets to go after. It's an interesting chicken and the egg conundrum because we likewise are advising our clients, you should go out and start thinking about getting D&O insurance like a traditional, public company would. And ironically, those are the sorts of things that interest the plaintiffs' bar because they know there's a policy behind there. Whereas in the past, you may have entities that could, disappear under basically a dissolution event or something. But I do agree that it's interesting in a way. I mean, I guess, if there's a silver lining, it is a sign that the industry is starting to mature because typically, again, the plaintiff's bar does not become interested until you have real viable entities and operations. But I do think that from a sort of a industry perspective, things are only going to get worse before they get better because I think, you've got now two fronts of potential litigation issues. We've always had the SEC, possibly sometimes CFTC, FinCEN, and now you're going to have to worry a little bit more about the private lawsuit side. And unfortunately, from a regulatory standpoint, I don't think the guidance is going to get any clearer anytime soon. We lucked out and were able to have host a fireside chat with Commissioner Pierce at our office. And I asked her, well, how are your new proposed rules coming along? And she was very nice, and without, sort of throwing her fellow commissioners under the bus, said, my colleagues have a lot to do. They're very busy. And, she was out clearly promoting the new rules that she proposed, but it seemed like they weren't getting a ton of traction. And this was before the crisis. Unfortunately, I don't have a real optimistic view that the rules or anything like them are going to get passed, in the next, I'd say probably couple of years, realistically.
This is all the more reason, as I mentioned at the beginning of our session, that having this legal protection, the champions of the good actors in space is, I think, crucial, more so going forward, especially now that I've been able to dabble in several platforms. I would say the big buckets being decentralized finance, DAOs, and NFTs, and there's a lot of good work being done, a lot of creative work, and it's a shame that a lot of the ghosts, the skeletons are coming out now. In hindsight, when in retrospect, rather retroactively, when a lot of this, some of the best work I've seen to date is being done right at this moment. So all the more crucial. Any thoughts from Emily or Steve on this point, or what you project going forward?
Well, I think you're exactly right, Stephen. I mean, what we're seeing is a lot of stuff in discovery from years ago that, things that were said in emails and the like that I think now people might regret a little bit in light of the new decisions that are coming out. I mean, if Telegram stands, there are a lot of skeletons in people's closets, and I think it will make fodder for jury trials and even bench trials that are going to be interesting and that are going to be hard for a lot of the companies in this space, even if they have really shifted in terms of how they're thinking about it now. What you said at the outset was right. I mean, the initial thinking was, we'll work this out, right? We'll break the industry and then we'll sort it out down the road. But I think that's going to be a big challenge for a lot of even very, big and impressive and valuable, projects in the space that are now going to need to contend with the fact that they are powerful, they are valuable, and there are skeletons at this point.
Well put, well put. Steve, how about yourself? What are you excited about? What are you encountering? What are some problems you foresee?
Well, just to kind of touch off on this point really briefly,
Sure.
2008, for anybody practicing in the space, like everyone on this, all the panelists here, that was truly amateur hour when it came to all of the ICOs and everyone calling, 6-10 times a week, trying to explain to us why their product wasn't a security and didn't need to register for anything. That was very laughable. And of course, I always explain to them, well, if it's not a security, what is it? Maybe it's a currency, and now you're dealing with my world, which is even more sort of elusive, if you will, and burdensome in its own ways. So luckily that sort of died out a bit, and because I'm not on the security side, I'm not seeing as much as it's happening on that side, though we are fairly active as well. What I am seeing more of sort of my world is more in what I call the tokenized platform space. A lot of interesting things happening there. No get-rich-quick schemes, no securities fraud, at least from what I can see, and some really kind of novel uses of tokens in various ways. Probably one of the more interesting ones is a project we've been working on for quite some time. I think it's almost done now, that had to do with film financing, which won't shock you given my introduction. And it actually had two different types of tokens. One was utilized to finance films so that, individuals could even invest in films. And another was utilized to access the content. And the first stream allowed for payments of royalties in a seamless way through blockchain and smart contracts. And the other promoted the currency for utilizing accessing the platform, rewards and other things. And we've seen that in other contexts like advertising, virtual reality, and we're seeing a lot more interest in decentralized and sort of tokenized platforms in general.
Very interesting. I definitely see how this revitalization of a lot of the legal disciplines in the sense that, for example, take NFTs. a lot of these markets are already fairly developed. I don't know if you've kept tabs on the crypto art market, for example, but a lot of these artists are making sales that rival or exceed that of traditional art, modern art, and it's surprising. At the same time, as we know, it's still very much kind of a pioneering space. So there, I'm sure copyright uh, IP issues abound, and I think those roosters also, they're on the horizon. So I think we will see a further revitalization of different fields, um, and it'd be great if we could get in front of these issues really, because I feel like it's always kind of cleaning up messes in hindsight. What would be some of the kind of if you had a forum, because this very conversation is being recorded for the greater forum. Of course, you're going to be allowed to strike anything off record if you like. If you could have words of wisdom for creators, for developers who are hard at work, who might not have in-house counsel on their teams, on the projects, words of fair warning, just to 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 let them focus on what they're doing, while at the same time not make mistakes that are either obvious or perhaps not so obvious. Any thoughts that come to mind? Any words of counsel?
Yeah, so this is Barbara. I think
Yes.
that's a really interesting question because it depends on if you're in the United States or outside the United States, right? So to Ken's point earlier, in terms of the proposed rules that Hester Pierce has out there, and with whether those will ever see the light of day realistically or not, and in what form and when. One thing that I've always been disheartened by, to a certain degree, is the fact that there are other jurisdictions around the world who have been taking the lead in a lot of these regulatory matters and thinking much more proactively than the United States has, rather than trying to fit a square peg into a 1933 or 1934 hole. And so that concerns me a little bit. And I understand the need to go slow and be thoughtful about it and think it all through. But I see the United States losing ground on that. So as you're looking, if you're a client, if you're a developer and you're saying, well, this is my idea, this is what I'd like to do, I think a number of developers are being advised broadly across firms to take it outside the United States and basically wait to bring it in until the United States catches up with you in a wide variety of areas. Now, obviously, if you want to play within the United States' current regulatory regime, that's great. We obviously encourage everybody to be in the United States to play within the regulatory regime, whether it's taxes or securities or FinCEN or whatever it happens to be. But if you're trying to really have an impact across a particular industry or within a finite field, you may be better in the near term to do that offshore. Work through some of the bugs, work through the regulators in a much more friendly jurisdiction, and then bring it back to the United States. Now, that being said, I have certainly seen instances where, whether it's even the IRS, but the SEC, the commodities, the CFTC, very willing to work with developers in structuring products for the market and working through very difficult issues. It's a process. It's a difficult process. Whereas, as I said, if you go to France, if you go to some other jurisdictions, there's a much more robust and open environment to be able to do that quickly. So I think those have to be balanced with what the clients or the developers' goals are, along with, what their time horizon is.
Well, very well put. I've had those same conversations with developers who, in many cases, are educated in the U.S., in Stanford, and so forth. And then when they actually want to start their projects, they will relocate you know, everyone can have different opinions on sovereignty and so forth. But I think one of our previous speakers on stablecoins, Catherine Gu, mentioned that, you know, there's so much kind of interlinkage with governments that uh, and human participation. Even the most decentralized systems, there is a very strong human element. We were talking about MakerDAO earlier, and really, you know, the sovereign system under which a blockchain platform system operates will have some influence on it. So even if you're of a very, very decentralized global citizen mindset, it will make a difference whether, you know, you work on your project in the U.S. versus in China, right? Or in Singapore, or in either of Koreas, etc. So it's really I think it behooves the regulators to pay attention to the arbitrage that's going on, and you know, there's nothing wrong with communication. So I agree with that point strongly. What else? What else is on your minds?
So this is Ken. I think one, you know, one thing that we've been talking about with regulators is trying to better educate, you know, the lawmakers and their fellow regulators. And I think there's still this this dark stigma to you know, the cryptocurrency and blockchain industry. People still, when they first hear about it, they don't know much about it. Lawmakers think, oh, it's a, you know, it's a scam, it's a fraud, it's a Ponzi scheme, or it's a way by which, you know, you can better launder money or something. And you know, you saw during the congressional Libra hearings, I mean, some of the, particularly the first round, some of the questions were just, you know, teeing people up to try to, you know, to go after them essentially. So, you know, I was talking to the commissioner about this after our talk, sort of what, you know, what she thinks would be helpful. And it's interesting. One thing is just better educating lawmakers and regulators on what some of the people are actually doing in the space. You know, some of the use apps are really pretty spectacular right now. I know people are using blockchain, you know, in connection with the crisis, right? The CDC. So maybe just even reframing the argument a little bit. I mean, really, if you think about it, the technology, it's kind of like every industrial revolution. When the telephone first came out, and you know, the light bulb, you know, people thought it was evil. It took them a while to get over that. You know, it was some pain and anguish and regulation. But it seems like there's just such a knowledge-based disconnect and misconception. And you know, maybe as an industry, if we work a little bit more on better educating the lawmakers and the regulators, particularly about the uses, that, you know, what is actually being done as opposed to just describing the technology, you know, perhaps that would move the ball a little bit. But I, you know, back to your question, Steve, and I agree with Barbara. What do you advise clients? It's really difficult. I mean, you know, on most matters, clients will come to you and you can tell them, all right, here are the guardrails, right? You stay within these guardrails, you'll be safe. You know, you get to the right or left, you're going to be, you know, in a risk zone. But it is very difficult to advise clients in this space because it's, you know, it's sort of moving guardrails a lot of the time. So.
Oh, it's well put. I think even with our journal, we're trying to publish content that it's not necessarily ideological, but tempered, balanced. And a lot of our articles are read by governments, actually. Regulators have reached out to our authors and so forth. So one of the pieces we're publishing these days in 2 parts is led by Yuta Takanashi, who is a deputy director at Japan's financial regulator. And it's all about regulators from his, because he also has a technical background, understanding the need that they can't do this alone, that they need multi-stakeholder cooperation to speak with engineers, the community, the users, and craft something that makes sense, because it's a bit scary. And this really hit home for me earlier with the DeFi talks, the stablecoin talk. But there are these financial systems that are being created that, from an arbitrage perspective, can be superior to anything that exists right now, right? Essentially, to be very crude, make more money more easily for participants who are savvy. And the problem with regulation is that if it's not crafted well, it can produce a product, a business product that no one uses because it's the constraints are too heavy or it's just not attractive for X reason. So and sadly, a lot of those kind of regulator informed products perhaps being more attuned to the concerns of governments, good, well-formed concerns. So I think, yes, we definitely need more communication. I agree with Ken. Guardrails keep moving. Not surprised. It's such a multifaceted space with such a diversity of actors, with many with very, very different, even clashing interests, ideologies. But the good news is I can be optimistic. I think, I've seen a lot of work by good actors who are making really fun things that even I can lose myself in. And I believe that we'll see, you know, more of waves of these kinds of excellent products that are actually better than what might exist in a centralized space. It's just a matter of time and patience, and I guess again, multi-stakeholder cooperation, communication. Anyway, enough spiel from me. We still have about 20 minutes. So what else? I can go back to the same question, or we can jump forward 2030 to a beautiful, hopefully a non-virus Latin world where.
Well, I would like to. I was just wondering if I could.
Go ahead, Rob.
Jump in.
Exactly what we're looking for. Actually, let's open it up. We can.
Yeah.
Questions, backward comments. Yes.
So what I'm interested in is a lot of the regulation, etc. And to be fair, I haven't been following it that closely for the last year or so. But a lot of it appears to be focused mostly around the idea of tokens. And as you've sort of discussed briefly, we've got these new types coming through, such as non-fungible tokens. And the implication there that they can rise and fall in value based on demand. And then we've got also the notions of DAOs or other forms of them, which are kind of sitting in a legal limbo because, from the US point of view, a DAO would largely fall under the unincorporated partnership or something else, and therefore leave liability to all individuals going through. But within the distributed finance, DeFi sort of area, you're kind of really starting to get to this aspirational goal, which was sort of framed by the notion of programmable money. But I think a better term for it is programmable capital, in the sense that you're actually structuring new types of automated or digital financial instruments that can be composed in a lot of different ways and to achieve different results, which in principle could be far more efficient, both from what Stephen mentioned from an arbitrage point of view, but more efficient in terms of allocative function by pushing both the source of capital to its productive capacity at the other end. So to give a really concrete example here is in terms of the work that I have been doing around impact bonds. So these are pay for results or pay for success, depending on whether you're in US or UK, kind of instruments which pay out when the project has been successful. And there's variations on those where there may be installment, milestone sort of payments, etc. Now, in principle, these instruments are framed by paper documents, right? But within the DeFi sort of space, we can do a lot of that far more efficiently in terms of programmatically, and that these instruments therefore become defined by a scripting language such as the smart contract stuff. But that efficiency gained from doing that is munted more or less by the fact that if I was to do an impact bond, I then have to do a complete prospectus. Paper form, go to market, go through all the proper regulation, etc., to be able to seek investment, which really kind of munts the ability of these sort of instruments to be far more efficient in their allocative function to move capital to where it's most needed. So what interests me here is is regulation, is litigation, or law firms, etc., are aware of this potential within these areas of particularly the DeFi side, distributed finance side of things. For example, we've got automatic liquidity exchanges such as Uniswap and Balance and a few others sort of coming through, or Bancor are doing these automatic liquidity providers. And I mentioned earlier things around bonding curves, augmented bonding curves, risk-adjusted bonding curves. These are kind of munging the notion of a market maker with shares, in a sense, which are far more accessible. But each of those sort of things exist within a legal limbo. So I'm curious in terms of opinions and etc., where they might, how they might be treated, where they're going, etc. On that front. Just any thoughts?
Yeah, so this is something I think about a lot of the time, and I agree with the comment that they're in some sort of legal or regulatory limbo. And I'll give the very unsatisfying legal answer of it depends in terms of what applies to them and what doesn't. And when we say them, the question is, well, the protocol may be totally decentralized and they couldn't do anything that if they wanted to, because they have no control, they've let go of control of it, but they may have interfaces that they themselves run and that connect to the protocol. And so then they have to think about whether any of the whole spate of laws apply to their interfaces. Can they at least do OFAC screening on the interfaces? Can they hire somebody to monitor the protocols because even though they've set it off and the protocol is running on its own as software? So you really do have to look at all of these different DeFi projects under a facts and circumstances test, because they all, the companies or the developers behind them all have different levels of control left, different interfaces that they use. Some of them have multiple interfaces which do lots of different things. You have to think about the APIs they've put together. So the answer is it depends, which is, I know, as I said before, highly unsatisfying.
I think,
So and that's also getting into the disconnect, isn't it, between the technology and the regulation. As I think Robert was saying, you can have this very sophisticated smart contract for financial instruments that will, once you sign on to it, it's going to self-automate. You're going to get your interest payments. You're going to get this, that, whatever it happens to be, or the swap's going to go through if certain triggers. But then on the other hand, maybe you still have to do a private placement memorandum, or you have to go through, all these other regulatory hurdles, if you will, in order to get that out to the market. So, that, I think, Robert, is a frustration, and it's not something that's going to get solved overnight. It will take time for that to evolve.
And Robert, just so you don't feel like you're alone, this is the whole conundrum of why there are so many unicorns now, like in Silicon Valley, for instance, right? So, if you look at the number of public companies and companies that have gone public, it just is nowhere near what it used to be. And if you talk to most of the founders of these companies, it's because they don't want to take on the regulatory cost and compliance requirements and everything else. And frankly, they'd rather just stay private. And, Commissioner Clayton, the SEC, has acknowledged this and said, we want to encourage more companies to be innovative and to go public and to employ more people. But despite the lip service, they really haven't done anything about it. And so it's interesting. There are a lot of what I would call traditional, company clients that I have that share some of the, I think some of the, feelings that you have about the disappointment and the inability to be able to innovate and launch products like this. Unfortunately, being a former regulator, the way I think that the U.S. government looks at it is, you're going to fall in one of the buckets. You're going to be regulated by somebody, and this question is how many. In some cases, maybe two or more. But until I think somebody gets together among the various different regulatory agencies and bodies and decides to have a an interagency view of the world, I don't think there's going to be a lot of clarity or less expense or burden on new companies, new products, especially virtual currencies and ones with built-in smart contracts raise any number of level of regulatory complexities.
Right. But in terms of what's going on here is that, as I said before, we've kind of got the singular notion of a smart contract. Take, for example, the ERC20s that manifestly create the tokens that a lot of focus has been on since 2017. But through the idea of protocol design, you're effectively saying we can compose these to achieve different forms of outcome. So it's not a singular smart contract or a singular protocol that I'm looking at here. Is that in the future, I definitely can see the ability to compose lots of different smart contracts into a graph that actually achieves a result. Now, my background is actually in, I've had about 10 years working in securities trading systems, etc. So I don't actually see these largely as being different from the existing commodities or equities or any of the bonds or anything else like that. From a technical standpoint, they're more or less the same. And we compose those in terms of our portfolio management, in terms of a distributed ecosystem that's called finance. The point here, in a sense, to want of a better phrase, is you're kind of democratizing finance. The high finance thing is being moved down. And that's where it's heading, okay? And this touches a bit, I think, on Barbara's point earlier around regulatory sandboxes that have been created to enable these sort of things to be explored. Singapore, Liechtenstein, Malta, and various other areas. So it's, in a sense, and the key point here being is about creating common value, I guess, in a way. In the view that a market, the pricing mechanism, for example, is supposed to distribute knowledge around so we can do allocated functions within the real economy. In a sense, these sort of tools can help us do that far more efficiently. I'm a big fan of regulation. I think it's absolutely necessary. I think it's the weight of regulation that needs to be addressed, given what we potentially, and I say potentially, but I'm fairly confident that we will be able to do.
Steve, it looks like you're muted.
Sorry about that. Thank you. I'll interject. We're going to go to Reina with her question next. I will say that the history of the internet can be very instructive. So without belaboring that point, I would point towards any reading of that. There was actually a UN-led effort that fizzled out, and then there was that led to some other constructive multilateral initiatives and so forth. Anyhow, Reina.
Hi.
Reina is our superb author of Blockchain Fiduciary Duty, which Vitalik himself enjoyed at our Stanford conference.
Really? He didn't tell me that, so thanks.
I took a picture for you, so I'll do it later. But yes, what's on your mind?
Yeah, so I have a few questions. In one way, they're selfish, but in another way, it's really for the benefit of my students. So I'm a professor at Wake Forest School of Law and at Duke Law too. And my students study blockchain, smart contracts, and crypto ventures. And through a number of regulatory lenses, like today we just had at Duke our class session on AML and KYC and FinCEN. We've already discussed the SEC and ICOs. The class ends on a project where the students in the past have done a due diligence report on some kind of token or crypto venture that exists in the space. For example, last year, my students performed a due diligence report on Binance, when they were still taking US investors. or US customers. And it was amazing because they saw a lot of their research really come into fruition over the summer. And they're like, oh, I called it. So the reason Binance kind of came on my radar last year was because I polled practitioners like, is there, a certain company you're kind of concerned about? You're wondering, what's going on there? It would be an interesting project for students to do a due diligence report on through these different regulatory lenses. So I was wondering, you know, for anything you're not conflicted out of saying in this session, are there other crypto ventures that you kind of have your eye on and you're like, I wonder, like, what's going on there? And if they're going to have to think a little bit deeper about compliance with these various agencies.
Great. Evan, any thoughts?
I might think on this one for a moment, given some of the conflicts issues.
Exactly.
Okay.
No worries.
I hear you.
No
I
worries.
have another question that I can have people
Well,
munch.
can I jump in on that? I would encourage your team to take a look at IEOs.
Okay, what's IEOs? I'm always learning something new.
Initial exchange offerings.
Oh, okay.
Yeah, I agree with that. Actually, that's great advice. I think they're being structured somewhat similarly to ICOs in a slightly different context, and certainly kind of applying the Telegram decision to IEOs and trying to think through what the implications may be would be a really interesting area for study.
Okay.
Yeah, and along those lines, as a general matter, a bunch of SEC staffers on the enforcement side who I know have told me that, they've been focused on issuers for a long time, right? But the next step, they're going to start focusing more on the exchanges.
Okay.
So something that might be interesting for you in your class to look at is how are the exchanges, handling these transactions? Do they meet the exemptions? And it's interesting in that, there's a real dichotomy between Commissioner Pierce's, regulatory guidance. She's actually saying you need to be more liquid and listed, which ironically kind of cuts against, the Howey test. But I do think you'll see more enforcement actions coming out against exchanges who are, not registered and are trading what the SEC has now, at least in settled enforcement actions, claim to be unregistered securities. So that's kind of a whole area without naming names, so to speak.
Okay.
The other thing I'd add on to this, just if you want a whole spate of things to think about, is one of the things that Telegram raised and the SEC raised in its arguments in Telegram is that all these investors are actually underwriters. And although the court itself did not address underwriter liability, there is a whole body of case law that talks about underwriter liability for selling unregistered securities. And so all of the investors in the space now need to start thinking about that post Telegram. So again, that's just a category and not a set of people, but I think that's a very interesting legal question, because one of the things that some people have raised post Telegram is, in addition to, doing investment docs, do you also have to give all of your investors underwriting agreements? Now, whether anybody would sign those is a whole other issue, but there has definitely been talk about that.
Interesting. And another question also for the benefit of my students, where do you see, opportunities for this coming graduation, or sorry, this, coming wave of law students in the crypto space? Like, what should they have on their radars, kind of maximize their opportunities in this space? So a lot of what we're finding, and my students find when they're interviewing, is that a lot of law firms will say they're looking into the crypto space or they have like a blockchain working group, but then it becomes clear that that's kind of aspirational. It's maybe on their website, but there isn't much behind it yet. So then when they're asking me like, where do I go, that's what I want to be, that bridge, because they're brilliant. And and they're so interested in these different topics that we're talking about, but I want to guide them to a place where they could actually bring those to the fore.
I mean, my advice, sorry, go ahead.
This is Brinley. So I am a general counsel, and I started in the crypto space. I was GC at Ripple for just about 2 years, and now I'm working on a project called Cello. And I would say the best way to learn as a lawyer in the space is actually going directly working with a project, if that's at all possible. Now, if you're a junior attorney, you want to have, I mean, you want to think about your experience overall in your career, and it's really helpful to go to a firm so that you can learn the basics of strategy and litigation and all of those things. But I think you will never get that upfront and personal, deep knowledge of this space unless you are working in it day in and day out. So if that comes in the form of a secondment, right? If you can get your firm to do a secondment and put you with a project, that's great for the firm and it's great for you. But there's nothing like that one-on-one discussion with your technologists, going deep into how something is working, and then you can think about the legal implications. Nothing like it.
Okay.
I can also say we've seen some amazing students who have, through their time in law school, have made a name for themselves in the blockchain space, on Twitter, by writing, but I mean, they've really gotten to know people, going to conferences. And, it's such a young space that young attorneys can come in with terrific contacts with all kinds of projects who could be potential clients for the law firm. And that's certainly something that, they may not know more about the legal issues than folks already working in the space, the law firm, but they might know a lot of people in the space starting startups. And that's something that we, certainly think about. We're all always looking for more clients.
Okay.
I do think, though, that they're experiencing the reality of law firms. So very few law firms, I'm not sure of any, maybe some of the folks on the phone, actually have a practice group that does blockchain. And there's a big difference between having a working group, having a multidisciplinary cross-practice group, and having an actual, practice group on your P&L. So, and I think it's the same thing with, with other areas. Our AI, practitioners have a working group, but law firms are frankly, and I agree completely with the prior, speaker. Law firms are slow, to meet the sort of the future. And I think, if they really wanted 100% immersion, it would be to go work with a project. Obviously, you get different things from a law firm, but there are, I think, are very few, if any, law firms out there who've established just a separate, complete, immersed, blockchain crypto practice group, like you would an appellate group or employment group, or something of the like. I think we're going to get there at some point. And, I think it's pretty exciting, but we haven't, I don't think the majority of law firms have gotten there yet.
The other thing your students can think about, and while I completely agree with Bryn that going to a project is really the best thing you do, is thinking about the particular practice area that may help them get into a project, and looking at firms that have really, that rather than looking specifically at a blockchain practice, you look at firms that have a really good banking group, or who knows the BSA really well, because having expertise on the BSA and AML laws and money transmitter laws is very valuable to most projects. And so concentrating on areas of law that are of particular import to projects and developing that, and then doing what Emily was saying, continuing to build relationships and things like that, could be really useful way to think about getting into a firm, and not going and looking for a specific blockchain practice group. So that's sort of taking everybody's advice and like hybriding it into one.
Yeah.
Great points. No, I agree. I think another thing that can be done is, I think a lot of the UI UX has improved to the extent that you can really dabble in a lot of these platforms. It used to be kind of Steven in the past. These days we have these virtual worlds that are gaining steam and getting popular. And I think it helps to really, if you start using these platforms, then you start sensing, especially with your students being awesome, they're going to have their radar on, right? And they're going to start seeing issues that might cause some trouble later on down the road. So I think having sharpening that awareness by actually using platforms, and then being able to talk to the firms or to other projects, whether they go in house or join a firm, etc. I think they're going to be able to kind of predict the future, and that's always a good thing in terms of finding clients who are, you know, or a little
We're
more
gonna need the help.
responsible. Right, exactly.
Okay.
Great.
Yeah, and I'll say for myself, my firm doesn't take associates just because of how it's structured, but I'm happy to speak to any of your students who are thinking and looking and trying to figure it out. So to the extent that will be helpful, I'm happy to do
Oh,
that
great.
too.
Thank you so much.
Yeah.
Thank you.
With that, if there are no parting thoughts, that was excellent. I think we got a really great cross-section of issues covered, thoughts, optimism, concerns, and I want to thank everyone on the panel. There's nothing else. Just want to thank you. Virtual clap.
Thank you for organizing, Stephen.
Oh, my
Yeah,
pleasure.
thanks, Steve.
I know you're very busy. Feel free to stick around. I believe Ruben will be